You know, after all these years on the bench, I thought I'd seen every variation of human desperation, every shade of moral complexity. But there was one case that came through my courtroom that still makes me wake up in the middle of the night, questioning whether I made the right call. It's the kind of case that doesn't have a good answer, only the least bad one. It was a cold January morning, the kind where the wind cuts right through your coat, and the sky is that oppressive gray that makes you wonder if the sun still exists. I was running late that day because my car wouldn't start, and by the time I got to the courthouse, there was already a crowd gathering outside. That should have been my first warning that this wasn't going to be an ordinary day. The case on my docket was a custody dispute, which normally wouldn't draw much attention, but this one was different. The parties involved were Marcus and Diane Chen on one side, and on the other side was their daughter, Rachel Chen. What made this extraordinary was that Rachel wasn't fighting for custody of a child. She was fighting for custody of her own mother. Let me back up and explain. Diane Chen was 62 years old and had been diagnosed with early-onset Alzheimer's 3 years prior. The disease had progressed rapidly, and she now required round-the-clock care. She could no longer remember her own address, frequently didn't recognize her husband of 40 years, and had episodes where she'd wander off if not supervised. But here's where it got complicated. Diane had moments of clarity. Sometimes she'd be completely lucid for hours, recognizing everyone, carrying on normal conversations, seeming entirely like her old self. Marcus was 70 years old and had been caring for Diane at home with the help of private nurses. He'd spent their entire retirement savings, roughly $800,000, on her care over the past 3 years. But now the money was running out, and Marcus had made a decision that Rachel violently opposed. He'd arranged for Diane to be enrolled in a medical assistance in dying program in Canada, where it was legal. In 6 weeks, if everything went according to plan, Diane would be given a lethal medication that would end her life peacefully. Rachel was 34 years old, a corporate lawyer in Boston, and she was seeking emergency custody of her mother to prevent this from happening. She'd filed a petition claiming that Marcus was not acting in Diane's best interests, that he was giving up on her mother, and that she would take over Diane's care herself. The courtroom was packed, not just with family members and press, but with advocacy groups on both sides. Right to Die organizations supporting Marcus's choice, disability rights groups supporting Rachel's petition, religious groups arguing about the sanctity of life. It was a powder keg. Marcus took the stand first, and I have to tell you, he looked like a man who'd already died inside. His hair was completely white, his face deeply lined, and he moved like every joint in his body hurt. His lawyer, a compassionate woman named Dr. Elizabeth Shaw, who specialized in elder law, guided him through his testimony. Marcus talked about watching the woman he'd loved for 43 years disappear piece by piece. He described coming home to find Diane had left the stove on and nearly burned down their house. He talked about the time she'd wandered out in the middle of winter wearing only a nightgown and was found 3 miles away, hypothermic and terrified, not knowing where she was or how she'd gotten there. He described her screaming at him, not recognizing him, accusing him of being an intruder in their own home. But worse than the frightening moments, he said, were the lucid ones. Because in those moments, Diane understood what was happening to her. She understood that she was losing herself, that the woman she'd been was being erased day by day. And in those lucid moments, she'd begged him to help her die while she still had some dignity, while she could still recognize the people she loved, while she could still make the choice herself. Marcus pulled out a video. He'd recorded one of Diane's lucid moments 3 weeks prior. His lawyer played it for the court, and I'm telling you, there wasn't a sound in that courtroom except for Diane's voice coming through the speakers. In the video, Diane was sitting in their living room, and she was completely present. She spoke directly to the camera, and she said her name, the date, and that she was of sound mind in this moment. She said she knew she had Alzheimer's, that she knew it was going to get worse, that she knew eventually she wouldn't recognize her own daughter or husband. She said she didn't want to live like that. She didn't want to become a burden, didn't want Marcus to spend his final years as a caregiver rather than a husband, didn't want Rachel to remember her as a shell of the person she used to be. She said she'd had a beautiful life. She'd been a teacher for 35 years, had influenced hundreds of students, had traveled the world with Marcus, had raised a daughter she was proud of. She said she'd had enough time, enough experiences, enough love, and she wanted to end her story while she could still recognize the final chapter, while she could still say goodbye on her own terms. The video showed her looking directly at the camera and saying that if anyone tried to stop this, if Rachel or anyone else tried to prevent her from choosing medical assistance in dying, they weren't doing it for her. They were doing it for themselves, because they couldn't let go. She said she loved Rachel more than anything, but this was her life, her body, her choice. By the time the video ended, half the courtroom was crying, including me. I had to call a brief recess to compose myself. When we reconvened, it was Rachel's turn. Her lawyer was a firebrand named Thomas Garrett, who'd made his reputation fighting for patient rights. Rachel took the stand and she was angry, passionate, barely holding herself together. She said her father was giving up, that there were new treatments being developed all the time, clinical trials, experimental medications, that her mother could have years left even with the disease. She said those lucid moments proved that Diane was still there, still fighting, and they owed it to her to keep fighting too. But then Rachel said something that reframed the entire case. She said that video, that statement from her mother, had been made 3 weeks ago. But yesterday she'd visited her mother, and Diane had been lucid. And in that lucid moment, when Rachel told her about the plan to go to Canada, Diane had been confused. She'd asked why they would do that, said she wasn't ready to die, that she still had time. Rachel had her own video. She'd recorded her visit on her phone. In it, Diane did seem lucid, and she did seem confused about the plan. She asked Marcus why he was giving up on her, why he wanted her dead. Marcus in the video looked exhausted and heartbroken. He'd tried to explain that it was what she'd wanted, that they'd discussed it many times. But Diane in that moment didn't remember those discussions. To her, her husband was planning to kill her. Rachel argued that this proved her mother couldn't consistently consent to medical assistance in dying, that Diane's wishes changed depending on whether she was in a lucid moment and which memories she could access in that moment, that her father was choosing to honor the version of Diane that wanted to die while ignoring the version that wanted to live. She said she'd quit her job in Boston, was prepared to move back to Providence, and would care for her mother herself. She'd already spoken to Diane's doctors about home care options, had researched memory care facilities, had a plan. She acknowledged it would be hard, acknowledged the disease would progress, but she said love meant not giving up, meant fighting until there was nothing left to fight for. Then Thomas put Marcus back on the stand for cross-examination, and it got brutal. He asked Marcus about the $800,000 that had been spent on care. He asked if Marcus was tired of spending money, tired of the burden of caregiving. He implied that Marcus wanted Diane dead so he could have some peace, some freedom in his final years. Marcus broke down on the stand. He said he'd give every penny he had, every day he had left, if it would bring back the woman Diane used to be. But it wouldn't. The disease was only going in one direction. And yes, he was tired. He was 70 years old with a bad heart and arthritis, and he was exhausted from 3 years of watching his wife disappear. But this wasn't about him being tired. It was about honoring Diane's clearly expressed wishes when she was at her most lucid. He said the video Rachel had shown was cherry-picked, that for every lucid moment where Diane seemed to want to live, there were 10 moments where she was terrified, confused, begging for it to end. He said Rachel hadn't been there for the worst of it. She visited once a week, saw carefully managed moments, didn't understand the reality of daily life with advanced Alzheimer's. Then Marcus said something that made the entire courtroom go silent. He said 3 months ago, during a particularly bad episode, Diane had tried to kill herself. She'd found a bottle of pills and swallowed as many as she could before Marcus found her. They'd rushed her to the hospital, pumped her stomach, saved her life. But Marcus said that moment had haunted him ever since. His wife, in her confused state, had been so desperate to escape her condition that she'd attempted suicide. He'd saved her that time, but he lived in constant fear of what she might do in her next moment of desperation. He said that medical assistance in dying, in a controlled environment with medical professionals, was a mercy compared to the alternatives. It was allowing Diane to die with dignity, peacefully, legally, rather than waiting for her to either waste away in terror and confusion or successfully harm herself in a moment of despair. I called another recess because I needed time to think. I went to my chambers and I sat there for an hour, reading through medical records, reviewing the videos, trying to figure out what the right answer was. The medical records told a grim story. Diane's cognitive function had declined 40% in the past year alone. She now required assistance with all activities of daily living. She had episodes of extreme agitation that required sedation. She'd lost 30 pounds because she often forgot how to eat or refused food. The neurologist's notes indicated that she was in the moderate to severe stage of the disease, with an expected lifespan of 3 to 5 years, most of which would be spent in an increasingly vegetative state. But there were also notes about the lucid moments. They were becoming less frequent, lasting for shorter periods, but they still happened. In those moments, Diane could recognize her family, could express preferences, could engage in conversation. The question was, which version of Diane got to make this decision? The one who clearly wanted to die while she still could, or the one who, in her confusion, wanted to keep living? When I returned to the courtroom, I did something unusual. I asked if Diane could be brought in. Both lawyers objected for different reasons, but I overruled them. I said I needed to see Diane myself, needed to try to understand her current state. They brought her in during the afternoon session. She was in a wheelchair, though Marcus said she could still walk with assistance. She was a small woman, thin now from the weight loss, with white hair and eyes that seemed to look through people rather than at them. A nurse accompanied her. I approached the bench carefully, and I spoke to Diane gently. I introduced myself, told her where she was, asked if she understood why she was there. She looked at me with those distant eyes and said she wasn't sure. She thought maybe she'd done something wrong. Was she in trouble? I assured her she wasn't in trouble. I asked her if she knew who the people in the courtroom were. She looked around slowly. She recognized Marcus after a moment, called him by name, smiled at him. She saw Rachel, and she knew this was someone important to her, but she couldn't remember the name. Rachel, sitting at the plaintiff's table, was crying silently. I asked Diane how she was feeling. She said she was tired, confused. She said sometimes she didn't know where she was or what was happening. She said it scared her. I asked her what she wanted, what would make her less scared. She thought about it for a long moment, and then she said she just wanted to rest. She said she'd been tired for so long and she just wanted to rest. I asked her if she understood that her husband wanted to take her to a place where doctors could help her rest permanently, help her sleep and not wake up. She looked at Marcus, and for just a moment there was clarity in her eyes. She said yes, she understood. She said Marcus was a good man, and if he thought that was best, then it was probably best. She said she trusted him. But then the moment passed, the clarity faded from her eyes, and she looked around confused again, asking where she was and why all these people were staring at her. The nurse said she was getting agitated and needed to rest. They took her out of the courtroom. I sat there for a long time after Diane left, just thinking. Then I made a ruling that I knew would satisfy no one but felt like the only ethical path forward. I denied Rachel's emergency petition for custody. I ruled that Marcus, as Diane's spouse and legal health care proxy under her advance directive, had the right to make medical decisions on her behalf. The evidence showed that Diane, during her most lucid and competent moments, had clearly and consistently expressed a desire for medical assistance in dying. The fact that she sometimes forgot this wish during her confused moments didn't negate the wishes she'd expressed when she was at her clearest. However, I also ordered a 6-week delay in any medical assistance in dying procedure. During this time, Diane would be evaluated by 3 independent physicians, including a psychiatrist specializing in dementia and medical ethics. If all 3 physicians agreed that Diane's prior expressed wishes were clear, consistent, and made with capacity, and that she was suffering in a way that justified medical assistance in dying, then Marcus could proceed. If any of the physicians had concerns about Diane's capacity to have made that decision, or if Diane showed a consistent change in her wishes during lucid moments, then the matter would return to my court. I also ordered that Rachel be given liberal visitation during this 6-week period, and that both Marcus and Rachel had to attend mediated family counseling sessions. I said that regardless of the outcome, this family needed to find a way to support each other through this tragedy, not tear each other apart. The courtroom exploded with reactions. The right to die advocates thought I was adding unnecessary obstacles. The disability rights groups thought I hadn't gone far enough to protect Diane. Rachel was sobbing. Marcus looked like he'd aged another 10 years. Nobody was happy, which usually means a judge got it about right. The 6 weeks that followed were excruciating. I received letters from both sides, from advocacy groups, from medical ethicists, from religious leaders. Everyone had an opinion about what I should have done. The case made national news. I was interviewed by medical journals, invited to speak at ethics conferences, all of which I declined. The 3 physicians conducted their evaluations. They reviewed all of Diane's medical records, interviewed her multiple times during both confused and lucid moments, spoke with Marcus, Rachel, Diane's doctors, even some of her former colleagues and friends. They were thorough and professional. The report came back 5 weeks later. All three physicians agreed that Diane's expressed wishes during her most competent moments had been clear and consistent. She had wanted medical assistance in dying before her disease progressed to the point where she could no longer recognize herself or her loved ones. The psychiatrist noted that Diane's confused moments where she expressed a desire to live appeared to be based on her not understanding or remembering her diagnosis and prognosis. When the situation was explained to her during lucid moments, she consistently returned to her wish for medical assistance in dying. However, the physicians also noted that Diane's lucid moments were becoming increasingly rare. She'd only had 3 during the entire 6-week evaluation period, each lasting less than 30 minutes. They expressed concern that if the procedure was delayed much longer, Diane might lose the capacity to provide any form of consent at all, even the implicit consent of not resisting the process. I scheduled a final hearing. Both Marcus and Rachel were present, along with their lawyers. Rachel had spent the 6 weeks visiting her mother daily, and the family counseling sessions had been ongoing. I could see that something had shifted between them. They were no longer sitting on opposite sides of the courtroom. They were sitting together. Rachel's lawyer spoke first. He said that Rachel had come to understand, through spending more time with her mother and through the counseling sessions, that her father wasn't giving up. He was letting go, which was different. He was honoring her mother's wishes in the most painful way possible. Rachel still didn't agree with the decision, still wished there was another way, but she'd come to accept that this was what her mother wanted. Rachel stood up and asked if she could say something directly. I allowed it. She said she'd been angry at her father for months, had accused him of wanting her mother dead, of being selfish, but spending time with her mother over the past 6 weeks, seeing the confusion, the fear, the moments where Diane didn't recognize her own daughter, had shown her what her father had been living with for 3 years. She said she'd found her mother trying to leave the house in the middle of the night last week, convinced she needed to get to school to teach her class, not understanding that she'd been retired for 12 years. She'd seen her mother break down crying because she couldn't remember Rachel's name. She'd watched her mother struggle to feed herself, to find words, to make sense of the world around her. Rachel said she still believed in fighting for life, but she'd come to understand that sometimes love means letting go. She said her mother had been a strong, independent woman who'd always valued her dignity and autonomy. Forcing her to continue living in increasing confusion and fear just because Rachel wasn't ready to say goodbye wasn't love. It was selfishness. She said she wouldn't fight the medical assistance in dying anymore. Instead, she wanted to be there with her father and her mother, to say goodbye while her mother could still, in some small way, understand what was happening. Marcus testified briefly. He thanked the court for the 6-week delay. He said it had been painful but necessary. It had given him time to work through things with Rachel, to make sure they were united as a family. He said Diane had one more lucid moment the previous day, and they'd told her together that they loved her, that they supported her decision, that they'd be with her at the end. He said the appointment in Canada was scheduled for 10 days from now. He asked for my permission to proceed. I granted it. I ruled that based on the physician's evaluations and the evidence of Diane's clearly expressed wishes during competent moments, Marcus could proceed with the medical assistance in dying procedure. I also ordered that Rachel be present if she wished, and that Diane be evaluated one final time by a physician in Canada before the procedure to ensure she was not actively resisting. I'll never forget what Marcus said as he stood to leave the courtroom. He looked at me with tears streaming down his face and he said, "Thank you." He said these past 3 years had been the hardest of his life, and having to fight his own daughter while trying to honor his wife's wishes had nearly broken him. He said the court had given him something precious, time to heal that relationship before it was too late. 10 days later, I received a letter from Marcus and Rachel together. They'd traveled to Canada. Diane had been evaluated by the Canadian physicians and had been having a lucid morning. She'd confirmed her wish to proceed. That afternoon, surrounded by Marcus and Rachel, holding both their hands, Diane had been given the medication. She'd fallen asleep peacefully and passed away within minutes. They wrote that Diane's last words, whispered to both of them, were, "Thank you for letting me go." Rachel wrote that being there, holding her mother's hand, seeing the peace on her face as she slipped away, had given her a sense of closure she didn't know she needed. She said it was the hardest thing she'd ever done, but also, in a strange way, a gift. She got to say goodbye while her mother still knew who she was. Marcus wrote that he'd been with Diane for 43 years. He'd held her hand through the birth of their daughter, through his mother's funeral, through countless moments of joy and sorrow. But holding her hand as she died, knowing it was what she wanted, knowing his daughter was there supporting the decision, was the final act of love he could give her. He said he'd been terrified of losing her for so long that he'd forgotten that letting her go peacefully was itself a form of keeping her safe. The case haunts me, not because I think I made the wrong decision, but because there was no right decision. Diane had Alzheimer's. There was no happy ending possible. The question wasn't how to save her, it was how to honor her autonomy and dignity while she still had some capacity to exercise it. I think about all the families dealing with similar situations who don't have the resources Marcus had, who can't afford private nurses or trips to Canada or expensive lawyers. I think about how many people are trapped in care facilities, not because they want to be, but because they don't have options. I think about how our medical system is so focused on extending life that we sometimes forget to ask if that life is worth living to the person living it. I keep that letter from Marcus and Rachel in my desk, not in the drawer with the other important cases, but in a frame on top of my desk where I can see it every day. It reminds me that sometimes justice isn't about applying the law perfectly. It's about giving families the time and space to make peace with impossible decisions. People ask me if I believe in medical assistance in dying now, if that case changed my views. I tell them it's not about what I believe, it's about respecting people's autonomy over their own lives and deaths. Diane made her choice during her most competent moments. My job wasn't to agree or disagree with that choice. It was to ensure that choice was respected, while also ensuring it was truly her choice and not someone else making it for her. That's what those 6 weeks were about. Not delay for the sake of delay, but time to verify, to evaluate, to give the family a chance to unite instead of fracture. Because whatever happened, whether Diane lived for 3 more weeks or 3 more years, Marcus and Rachel had to live with the decision for the rest of their lives. They needed to make it together. I don't know if that case will ever stop keeping me up at night. I don't know if I'll ever feel completely at peace with my ruling. But I know that Marcus and Rachel found peace with it, and I know that Diane died the way she wanted to die. In a world where so much is beyond our control, where diseases like Alzheimer's steal everything from us piece by piece, maybe that's the best we can hope for. The dignity to choose our ending and the family support to make that choice surrounded by love. That case taught me that being a judge isn't always about being right. Sometimes it's about being thoughtful, being compassionate, and being brave enough to make difficult decisions even when you know half the world will disagree with you. And sometimes, if you're lucky, it's about giving families the gift of time to find their way to peace, even in the midst of tragedy. V.